falling emergencies, somehow morphed into an everyday tool in Nigerian constitutional law. It's basically a story of political survival, deep legal theory, and, well, what happens when courts are forced to make absolutely impossible choices.
To get through this, we've got a 5-part agenda today. We'll start with the core legal paradox, move into surviving the military era, look at the civilian slippery slope, compare it with the covert American approach, and finally wrap up with setting doctrinal boundaries.
All right, let's jump right into Section 1, the core legal paradox. Basically, a supreme constitution versus an overriding necessity. So to really grasp this, we have to start with the core concept. There's this Latin formulation, necessitas non habet legem, which translates to necessity knows no law. What this means is that the doctrine of necessity justifies an action that is technically illegal purely because the alternative is so much worse. Think of it as the legal equivalent of breaking a window to escape a burning building, right? The law generously looks the other way because staying inside that building would be fatal. Now, this doctrine actually makes perfect sense in the United Kingdom. Why? Because the UK has an unwritten constitution based on parliamentary sovereignty. It's bendable by design. But apply this to Nigeria, and you hit a massive roadblock. Nigeria has a written constitution. It is the supreme basic norm, the grunge norm. Sections 1.1 and 1.3 literally say the Constitution is supreme, and any law inconsistent with it is absolutely void. And that brings us to the crux of the problem. Akhigbe powerfully points out that, logically, you just cannot have a supreme constitution while at the exact same time using a doctrine that lets necessity override it. If necessity can somehow resurrect a void, unconstitutional act, well, then the Constitution isn't really supreme, is it? Trying to claim both are true at the same time is basically trying to have your constitutional cake and eat it too. Moving on to Section 2, surviving the military era, or how the British house guests moved in and just refused to leave. So, you might be wondering, how did Nigeria even end up adopting this totally contradictory doctrine in the first place? Well, the answer is in the history. We're looking at decades of repeated military coups in 1966, 1983, and 1993. These created massive constitutional voids, where the Constitution was just repeatedly suspended or completely abrogated by force. This crazy reality backed the nation's courts into an impossible corner.
When the courts were confronted with military rule, they essentially had 2 choices. Option 1 was strict theory. They could declare every single act of the military government void. But actually doing that would plunge the whole country into a legal abyss. Imagine 50 years of everyday contracts, marriages, and governance just becoming legally meaningless overnight. Total chaos. So instead, they pragmatically went with option 2, accommodation. By drawing on Kelson's theory of effectiveness, which basically says a government that's effective in reality gets legal validity, and the common law doctrine of necessity, they invited this emergency doctrine into the constitutional house just to keep the country running.
But men, this was a dangerous game. The tension of this whole era is perfectly captured in the 1971 Lawson case. In this landmark decision, the Supreme Court actually showed incredible backbone and struck down a military decree. But what happened next? The military government just turned around and immediately passed a brand new decree overturning the court's decision. As Akhigbe notes, it was a really harsh lesson for the courts about the severe limits of playing the judicial hero under a military regime. That takes us to Section 3, the civilian slippery slope, from constitutional crisis to everyday judicial utensil. Now, logically, you'd probably expect that when democratic civilian governance returned in 1999, this emergency doctrine would be locked safely back in its class case. But no. Instead of saving necessity for actual state survival, the court started using the doctrine for totally ordinary disputes. It got stretched way, way beyond its intended limits. Akhigbe makes this great comparison. He says it's like a tailor forcing a suit onto a client who just gained 30 pounds and swearing it still fits perfectly. The burning building? It became room temperature. Breaking the window basically became a lifestyle choice. We see this expansion jump right out of the case law. Take the 2008 Rotimi Amashi case, where the Supreme Court actually used necessity reasoning to validate a political party substitution, which, by the way, had absolutely zero explicit constitutional warrant. And then in the 2007 Abu Bakr case, they used it again to navigate a vice presidential succession dispute. This shows a really stark shift. A doctrine meant for the literal collapse of the state was now just being pulled out for political and judicial convenience. So, how on earth do the courts justify doing this? Well, they usually lean on 3 main arguments. First, the idea that the welfare of the people is the supreme law. Second, the need for constitutional continuity. And third, judicial gap filling, which they base on Section 6 of the 1999 Constitution. Now, Akhigbe is quick to point out that while judicial gap filling is intellectually honest and theoretically defensible, claiming the welfare of the people, that is incredibly dangerous, because you can use that to justify almost anything.
Let's shift gears for Section 4, the covert American approach, sublimating necessity into other doctrines.
It is absolutely fascinating to compare this Nigerian situation to another country that also relies on a supreme written constitution. Let's look at the United States. Does the U.S. have a doctrine of necessity? Well, the official, by-the-book answer is no. But the functional, real-world answer is absolutely yes. They just camouflage it. Akhigbe compares it to a restaurant in a dry county that secretly serves alcohol by calling it specialty fruit beverages. Everyone in the room knows exactly what it is, but nobody actually says it out loud.
And honestly, they pull this off brilliantly. They do it through concepts like Justice Jackson's famous concurrence in the 1952 Youngstown case, where courts implicitly grant the executive branch deference in emergency gray zones. It's basically a necessity wearing a separation of powers trench coat. You see the same thing with the political question doctrine, where American courts just flat out decline to examine certain military or foreign policy acts. They let executive necessity operate entirely through judicial silence, which Akhigbe cleverly calls passive necessity.
We see this super clearly in high-stakes post-9/11 jurisprudence. Think about cases like Hamdi in 2004 or Boumediene in 2008. The U.S. Supreme Court was navigating a massive head-on collision between constitutional guarantees and national security. They never once invoked the doctrine of necessity by name, but the functional reasoning they used, the idea that emergencies require flexibility, that was pure necessity reasoning, just wrapped up tightly in judicial camouflage.
And this highlights the fundamental difference between the two systems. Nigeria is candid. It honestly names the doctrine out loud, but by doing so, it leaves it completely vulnerable to abuse by creative lawyers. The U.S., on the other hand, is covert. It subtly hides necessity within existing constitutional structures, which actually prevents it from running wild as some independent standalone excuse. All right, finally, Section 5, Setting Doctrinal Boundaries, Managing an Inescapable Theoretical Problem.
Akhigbe stresses that this foundational problem we've been talking about, it can't actually be resolved. Claiming you have a supreme constitution while simultaneously having an overriding doctrine of necessity is exactly like insisting you are both the tallest and the shortest person in a room at the exact same time. It's literally logically impossible. Because of that, it can't be solved. It can only be managed, and that requires extremely strict doctrinal discipline.
To manage it, he outlines 3, and literally only 3, defensible spaces where necessity actually serves the Constitution instead of just steamrolling it. Number 1, filling genuine constitutional gaps where the text is totally silent. Number 2, at an existential threshold purely to preserve the constitutional framework from total destruction. And number 3, acting as a transitional instrument to bridge periods of constitutional rupture and get things back to normalcy.
The big takeaway here is absolutely vital. If you don't have disciplined limits keeping the doctrine restricted to just those 3 spaces, it morphs. It stops being a tool for constitutional preservation and becomes a highly convenient judicial override button. Because a doctrine of necessity without limits isn't really a doctrine at all. It's just a roving judicial license to ignore the text whenever it happens to be convenient. I want to leave you with this final, highly provocative thought from Akhigbe's analysis. He says, a constitution that can be overridden whenever a court decides it is necessary is not so much a supreme law as a very strongly worded recommendation. Really think about that for a second. If a foundational text can just be bypassed at will because someone shouts necessity, how secure is a democracy's rule of law really? It is a heavy question that every single constitutional democracy has to answer. Thanks for joining me for this explainer, and remember to always keep